The Supreme Court ruled that Tamil Nadu Governor R.N. Ravi's action of withholding assent to 10 bills passed by state legislature and forwarding them to President after they were reenacted by state legislature was illegal, non-est factum and erroneous in law. As a result, any subsequent action taken upon said bills by President also does not survive and is thus set aside, ruled a bench comprising Justices J.B. Pardiwala and R. Mahadevan. Supreme Court ordered that since the bills remained pending with Governor for unduly long period of time and Ravi did not act in a bona fide manner by reserving the bill for President's consideration, the bills are deemed to have been assented to by the Governor on date when they were presented to him after being reconsidered by the legislature. Hence, any consequential steps which might have been taken by President on said 10 bills were also declared non-est in law, Supreme Court held. Verdict authored by Justice Pardiwala said, having regard to unduly long period of time for which these bills were kept pending by Governor before ultimate declaration of withholding of assent and in view of scant respect shown by the Governor to decision of Supreme Court and for other extraneous considerations that appear to be writ large in discharge of his functions, we are left with no choice but to exercise our inherent powers under Article 142 of Constitution to declare these 10 bills to have been deemed to have got assented. Bench ruled that option under first proviso to Article 200 is not independent option and this must be exercised in conjunction with the power in substantive clause of Article 200. This means that once Governor declares that he was withholding assent to the bills, he must then send back the bills to the Assembly for reconsideration. Argument by Attorney General R. Venkataramani that when the governor declared that he was withholding assent, he did not send them to assembly, and hence it was not open for the assembly to reenact them, was rejected by the bench. The bench held there is no concept of absolute veto or pocket veto under constitutional scheme. As per Article 200 of Constitution, Governor is expected to take one of the three courses of action on bills: grant assent to bills, withhold assent to bills, or reserve the bills for the President, the bench ruled. The top court further held that the bill can be reserved for the President only at the first instance. As a general rule, it is not open for the Governor to reserve a bill for the President after bills have been represented by government after being passed again by Assembly. The only exception is when the bill presented in the second round is different from the first version, the judgment read.